Everyone, welcome to our fifth lecture for NCA Constitutional Law exam. So today's topics are repetitive ones, so that is why this lecture is going to be very short. I'll be just giving you a brief overview once again that we have already discussed in detail in our previous lecture on judicial review. So these two topics. Now let's begin. When you look into syllabus, you will see for the paramountcy topic, for this doctrine, it is straightforward written that you have to use this whenever there is a conflict between validly enacted. So this word validly is important because in case scenario, how you are going to use these different doctrines, so you have to follow the wording of syllabus. So if you feel that there are two legislations, both are valid at their own place, and you feel that the federal law is having more power, is so having more supremacy over the provincial law, then what will you do whenever there is a conflict between two valid federal and provincial laws? So the principle of paramountcy says that the supremacy of federal law will prevail. It means provincial law will be held null and void, will be declared invalid, and which law will only prevail? Only the federal law. Next is interjurisdictional immunity. So for this, what we say? So whenever any level of government tries to enact law that comes under core area. Core area means main area, direct area of one particular authority. So we are using this doctrine. We are saying that you cannot interfere to the jurisdiction of another government. So this protects certain core areas of federal provincial jurisdiction from interference by other level of government. So for paramountcy, we have already discussed this topic earlier in judicial review, as I told you. So provincial law will remain valid but won't be applicable. Federal law only will stand valid, it will only prevail. So this you have to see that in writing it will valid, but in practical application it will be null and void. So according to this doctrine, wherever you will see a conflict between two valid laws, one enacted by province, one enacted by federal government, the federal law will be stand valid. You have to take decision as per federal law, rendering the provincial law inoperative to the extent there is conflict. Rest remaining law, which is at no conflict with the federal law, that will remain valid, that will prevail as it is. So here we are saying that only null and void to the extent, to the areas, those provisions which are in conflict with federal law. So paramountcy arises in two cases. Firstly, when there is operational conflict, there are two valid law and you have to follow one particular law, and then their conflict arises. And secondly, when the federal purpose is completely frustrated, you feel that the main federal purpose for which a particular area has been included into the federal authority, that main purpose is frustrated, or the purpose of particular legislation law is getting frustrated. So three-step process is employed whenever you have a question related to federal paramountcy. Firstly, you will see that whether both laws are valid or not. Then you will see that if the law fall under different areas of authority and apply that to same activity, same conflict. Then you will see that whether both can stand operative at their own position, whether we can go for cooperative federalism, whether they both can serve their purpose. If not, then you have to go to step 3. If compliance of both law is impossible, you feel that both law cannot stand valid, cannot run side by side due to contradiction, or if the provincial law frustrates the purpose of the federal law, so then provincial law will become inoperative, only the federal law will subsist. So these are the cases. This Rothman case we have already discussed in judicial review. So this is new case here, Law Society of BC versus Mangat 2001. What happened in this case? Mangat was an immigration consultant, faced legal action for practicing law without proper accreditation. So he was not any certified lawyer, he was not registered with any bar, he was simple immigration consultant, but he was practicing law. So conflict arose between federal law, which allows no non-lawyer to represent refugees, provincial legislation prohibiting such practice. So this was the conflict. So one federal law is allowing non-lawyer to provide such kind of legal immigration services to refugees, and provincial law is banning. So court concluded that federal law here took precedence due to the conflict and frustration of federal purpose. Here the federal legislation wanted to have a broader perspective, broader area in which they said that okay, immigration consultant here are only providing administrative services which anyone can provide. So this is more of this is more of administrative service than going for directly straightforward a legislative service which a lawyer provides. So here the federal law prevailed over the provincial law which prohibited such practice. So in this case, federal law took precedence due to conflict and frustration of federal purpose, because federal purpose was made for some different objective and provincial law was made for some different objective. So here Mangat was allowed. Next case we have already discussed. Then comes second topic, interjurisdictional immunity. So this doctrine comes into picture when a provincial law, even if valid, is encroaching federal jurisdiction. For example, federal government has enacted some law and provincial government in a way has directly enacted a particular law on exactly some area. So under this doctrine, the provincial law will render inapplicable if the federal government hasn't legislated on that matter. So even if we have no federal law on a particular area, like for example aeronautics, the federal government has not enacted any law, but it does not mean that provincial government can enact a law. This is like going from section 92 to 91, which is impossible, not possible, invalid, completely illegal. One cannot do that. So this is interjurisdiction when 92 is going to 91. So provincial laws must not have any incidental effect. The interjurisdictional immunity safeguards specific matter falling under federal jurisdiction from provincial interference. So provided that law should not have incidental effect. We have earlier seen in other doctrines that if there is an incidental effect or if it comes under ancillary part, then we let the provincial government to enact and to go further, then we look into other things. But here we are talking about direct enactment of a law on one of the subject which is under the jurisdiction of federal government, so which is directly under the jurisdiction of federal government. So we will elaborately see this doctrine in the case of Quebec Attorney General versus Canadian Owners and Pilot Association 2010. So here two individuals in Quebec built a landing strip and hangar on their land. One was killed before the Supreme Court appeal, so the Canadian Owner and Pilot Association represent them. Two individuals were ordered to shut down the strip and restore the land back to normal under the Provincial Act respecting the preservation of agricultural land. So this was the provincial law. But under the aeronautic law, which is federal government law, had jurisdiction over regulation of aeronautic throughout Canada, allows the construction and use of private airfield as long as certain conditions are met. So you can see here that two different provisions, two different governments, two different law. One is saying some other thing, one is allowing, one is prohibiting. So provincial legislation regulated land use and federal legislation regulated aeronautics. So here we have two different areas. So this is related to land use and this is related to aeronautics. Step 1. Are both acts valid? So as per section 95, provincial government is allowed to make any law related to agriculture. We read this earlier. And as per section 91, federal government has jurisdiction over aeronautic. So here one thing you have to keep in mind that the subjects are different. Subject is not same. Provincial legislation is under the subject that comes under provincial authority, and this is under the subject that comes under federal authority. Now where's the conflict? So both are valid exercise of power. Step 1 clear. Step 2. Does the Provincial Act apply in situation where it impact a federal head of power? So this is where interjurisdictional analysis comes into picture. So does the provincial law interfere entrenched on a protected core of federal competence? So core competence of this federal law is aeronautic and aviation. So federal government has exclusive jurisdiction over the airfield, aeronautic, aerial navigation. Jurisdiction include regulation operation of aircraft. So we are here seeing to what extent the federal government has jurisdiction. So this extend to location of airport. But provincial government argued that personal airfields should be excluded from the definition because they are not matter of national importance. That is why they should not come under federal authority. However, court said that local aviation falls under federal jurisdiction because subject matter here is not separable. You cannot separate the land below to a particular aerial. So aerial, whenever there is some airfield, you cannot just keep the federal authority restricted to the air area. You have to include particular that land area as well. So here you cannot separate land and air. They fall under federal jurisdiction under the peace, order and good governance part. So then here this doctrine also came into picture in this case. So next is, does the law affected on the protected core of federal competence is sufficiently serious? So is it that serious interference that one should have to invoke the interjurisdictional immunity? So the test is whether the subject comes with essential jurisdiction or just the base minimum. So the core federal power is the authority that is absolutely necessary to enable parliament to achieve the purpose for which exclusive legislative jurisdiction has been conferred. So you have to look at the core of particular competence, how important it is, what area the provincial law has affected. So here the main area, the airfield, aerial navigation, aeronautic, everything got affected. This means that some provincial law will be valid that affect airport because it does not affect the core of federal competence. But the area, the land that comes under the central government, that comes under the federal authority, definitely is something of core nature, something of very important. So interference must be unconstitutional. So just because the federal government chose not to legislate, not to enact any particular law which says that their airfield lands, the ground area comes under federal authority, which is I think an obvious thing. So provincial law cannot impair such thing. So this is important line. Similar thing I told you earlier as well. So this is one big difference between federal paramountcy and interjurisdictional immunity. So paramountcy is not applying here because there is no operational conflict. Because federal legislation does not require the construction of aerodrome. If they required the construction, they only said that this area, the below land comes within our authority. So they are not saying that we are encroaching upon your any core area, your authority. So that is why we are not applying here federal paramountcy. Only the interjurisdictional doctrine will apply here. Then there is this case which we have already discussed in judicial. So in this case, the court took a four-step process for interjurisdictional immunity. First, is there a provincial law that seeks to regulate a federal matter? If yes, does that law entrench upon the core of federal competence? If the core has been affected, is it sufficiently serious that we have to bring forth any doctrine? If yes, then provincial law will not prevail and interjurisdictional immunity will apply. Then in examination, if you're getting such question, you can also see and you can just mention in few lines that okay, why in this particular case we are not bringing the federal paramountcy as I told you in the earlier case. From there, the lines you can take up and write in examination as such, just paraphrase those, that the areas where there is no operational conflict, then we don't apply federal paramountcy. So that is why we are only applying interjurisdictional immunity doctrine. So this is how you're going to attempt the question. So that's all for today. Thank you and good luck.